none of my lawyers could figure this out. Also, the judge here stipulated to the workers' comp that he was going to take it over. Latham & Watkins got him to stipulate, and the trustees. And here there was no workers' comp since April 1st, 2001. So that's the attorney disclosure 310. I did file a fraud complaint. It is in action in Riverside Federal Bankruptcy Court as of today, which is December 6, 2008. And I'm still in Kern County in Bakersfield fighting for my personal injury against Cedric Claims Management. Not sure how this is going to go without there being any general liability. I was hoping to get compensated about $5 million from the general liability, but here they don't have any workers' comp or general liability for the big semi-trucks. So, anyways, I go back to court one more time, and I try to, the law for malicious, willful malicious, I try to get it on the secure, because I had put it in the unsecured, and that's what the judge just told us. But there's a law saying it's secure, you know, like the drunk driver that I was telling you. You can't just declare bankruptcy after he injures you. And so, anyways, this judge is saying it's been taken off the books. I don't believe the legislators did wipe this out, but, you know, they're the judges, and you have to go along with this system. But anyways, I still think I'm going to prevail in the state court system. So I'm going to go ahead and put that on.
Calling the matter of Consolidated Freightways, objection to claim of Laura Koski, appearances, please. Good afternoon, Your Honor. Michael Lurie of Latham & Watkins, appearing for the trust.
Laura Koski in person.
I've had a chance to read the papers. Ms. Koski, here's what I need to tell you. You cannot file a claim based on prospective damages down the future as a priority claim. You've been able to file whatever claims you've been allowed for any damages you claim may have existed as general unsecured claims, but the whole code on priority claims is for a period of time between the date of the bankruptcy and 90 days beforehand, to the extent you were an employee. To the extent those have already been paid, whatever those priority claims were. Any other claims you may have, to the extent they're allowed, will be general unsecured claims that will be paid pro rata with all the other creditors, including all the other employees whose claims either exceed or whatever aren't covered by the priority claims. What got you to believe that you could file a claim for prospective dental work because they canceled their insurance? You have a right for unpaid medical. Well, we'll see about that first, if you were a retiree, but if you were working, to the extent they were incurred before the bankruptcy and within the 90 days before. That's the law. How do you justify what you've done here? This is what's bothering me.
Yeah, I was under the understanding when I had talked with you to, if they had paid me unpaid medical, that I could go ahead and submit to reclaim the $994.
Well, I made it very clear at the last hearing that to the extent you had any unpaid medical bills, maybe you didn't understand, that were incurred before the bankruptcy.
Okay, no, I did not understand, and I did call Kim Posen 3 times and left a message to address the submission of the dental bill, and she never returned my call. So I don't feel it's fair that...
Well, I'm not going to sanction you because I really basically said, look, you get one last shot at it, and to the extent you're going to raise a 507A4 claim up to the 900, because I told you you were left with 994 as a priority claim. I mean, whatever claims you've had that relate to general unsecured or general unsecured, but the code is very narrow as to what can be paid at the top of the pile, and priority claims are top of the pile. And it has to have been incurred before the bankruptcy and within a 90-day window of the date of the bankruptcy. And obviously, you've submitted all that. They paid off the $994. They've determined that you did, in fact, have priority claims to the tune of about $3,500 or $3,600. There's no other priority claims, and this doesn't constitute that, and I'm not letting you come in anymore.
Right. The only other justification I could say is I did submit a lot of medical bills, and that maybe perhaps within that time frame you could consider those, because there were undental bills that were not paid, and I had submitted them.
Well, I know you submitted dental bills, but the time frame has got to be that you had dental services that were rendered to be covered by your medical insurance portion, that where the services were rendered between, what was it, July 2002, Mr. July, July 2, 2002. To September. Anything in any other period can be filed as claims, but they're general unsecured. They are at the back of the bus with everyone else. Now, I don't believe in the material you filed that I could see. Well, I haven't seen what the nature of the claim is. Maybe I need to pull the claim. Was there anything in the claim that was during the period of 2002, June 2002, Mr. Larry?
Your Honor,
I see all of the claims for June 2006.
Response.
Yeah.
Then there's a bill attached, which shows services in June and July of 2006.
Right. All I have is the work for Mr. Girardi, the Dennis Girardi in 2006. I don't have anything else. In this claim that you filed, this is the one I'm dealing with. And it was your responsibility to go through and say, well, wait a minute, there were some medical bills not covered by the $3,600 I already got that occurred between June 2002 and September 2002. I think you submitted all those pretty long time ago, and they were looked at a long time ago.
Right, I did submit them, and I'm trying to just think here. My accident was August 4, 2002. So it had to be before the accident, or
No.
just after 90 days afterwards?
The law is the period, June 2, 2002 to September 2, 2002.
Okay.
Services incurred, these are called pre-petition, okay? Priority claims that were incurred within the 90 days. Incurred means they had to happen. You may have been injured in August of 2002, but if you went to the doctor on that injury in August of 2002, in late September 2002, you got a priority claim. It's only general unsecured because it doesn't fall within the priority.
Okay.
All of your medical bills, all of your injury claims, to the extent they are not covered by insurance or covered by the self-insurance of the company, only can be classified if it doesn't fall in that narrow window for a narrow amount of money. Can only be classified as unsecured claims. And you have filed God knows how many unsecured claims for God knows how many theories.
Right. Okay,
We got to be done with you once and for all.
I'd like to be done with this.
Well, and you're not going to get paid right away. No one's getting paid while all these things are hanging out there.
No, I understand that, and I was trying to basically get a reconsideration on the it was an invalid workman's comp to try to address these issues. It's been difficult. I've had several attorneys who didn't know the law, so it's hard.
But this court can only say that this claim doesn't qualify. The trustee is tired of incurring, because the fees the trustee is incurring, when you don't figure it out right, all the creditors pay for it. You are hurting your fellow employees right now. And whether you care about them or not, I do.
Oh, I do.
And I'm not going to let you back into this court again. You are done. You have filed claims. You had a chance to figure it all out. If they don't understand it all, you go back, and if you feel you need to look through your records, you only have one remedy left. I'm telling this to you straight out. You have a remedy called reconsideration. This claim is no good.
Okay.
I'm not letting you back in because we've looked at all your claims. The trustee has been as patient and as courteous as possible. And if I recall, Mr. Leary, doesn't she have an estimated claim out there, the general unsecured claim for like $5 million? I don't know if that's
Your Honor, she does. But if I may speak, I don't want to interrupt you or Ms. Koski.
Go ahead.
She has an appeal at the Ninth Circuit because remember she's filed an adversary proceeding. The reference was withdrawn to the district court, and that case was dismissed with her consent. And now she's going to the Ninth Circuit to reconsider that. If she loses there, Your Honor, I don't think she has any valid claims against the trust. If she's successful at the Ninth Circuit of having them reopen that, then yeah, she would be back before you, and that claim was estimated at $5.6 million.
Right.
You've stated our position very well, Your Honor, and this is not personal to against Ms. Koski, but she has through filing, 5 different claims for up to $240 million over 4 years, cost the estate $100,000 of expense. We tried to settle this latest claim and offer her a small amount, but well above the priority level to settle everything, either settling the appeal or not settling the appeal. And I won't go into the details, it's not proper, but we were nowhere close. So she has a right to have the Ninth Circuit appeal heard, unless, as we hope, the Ninth Circuit rejects the appeal that it was untimely. And if the Ninth Circuit rejects her appeal, Your Honor, we think she's exhausted her judicial remedies. And I understand you're not going to sanction her for this claim, although it's, I think, frivolous. But what I really would request of the court, as you just said, that she should not file any more claims. Her claims are already, 3 years beyond the bar date. Frankly, I'd like you to go further and tell her if she files claims in violation of today's order, she will face sanctions. Because
That's what I was going to tell her. That if she does this again, that she may end up having to pay something out of her pocket.
And, Your Honor, the other element that we would urge you